listening to Driving Law, a podcast by Kyla Lee about all things related to the rules of the road.
Hello, and welcome to another episode of Driving Law. I'm Kyla Lee at Acumen Law, and with me, my co-host, Paul Doroshenko.
So, big news this week.
Wow, yeah, a huge Supreme Court of Canada decision released today. One we've talked about before. We talked about it when the Saskatchewan Court of Appeal released it. Then we talked about it again when the hearing happened at the Supreme Court of Canada.
You watched the hearing?
I watched the hearing, and now we have the decision. So the case is called Singer. This is the one about whether the police can enter onto your property to go knock on your door or the door of your car, in Mr. Singer's case, for the purposes of investigating a complaint of impaired driving. Basically, can you investigate that complaint, or do you need a warrant?
By just walking onto your own private property, they see your car parked there, can they just go trucking into your yard?
Yeah. The Saskatchewan Court of Appeal had found that no, although there is a license at common law to allow police or anybody to enter onto somebody else's property for the purpose of knocking on the door and communicating with the occupants, the implied license that permits police to do that does not expand to include permitting police to come onto your property for investigative purposes. Because why would anyone consent to letting the police on their property for the purposes of investigating them? That's ridiculous.
Yeah, I mean, the police are there to investigate something. They're there to collect evidence, and so they're going onto your property with the full intention of being there to collect evidence.
Yeah.
So why would you, I mean, the assumption that I would have is that, no, you're not invited to come to my property if you collect evidence. You could phone me, and I will tell you I don't want you on my property.
Yeah.
But
and so it's interesting that you brought up collecting evidence, because that's really where the distinction is being drawn now by the Supreme Court of Canada, who overturned the Saskatchewan Court of Appeal and ruled that police do have the authority to enter onto somebody's property for the purposes of communicating with that person, provided that communication is their objective. If their objective is to gather evidence, and they're intending to communicate for the purposes of gathering evidence, that is not permissible.
So it was just released this morning, and was not what the Magic 8 Ball predicted. The Magic 8 Ball predicted that, and when I say that, this is my prediction.
Oh, okay. You're the Magic 8 Ball.
I was thinking about it. I had predicted that the Saskatchewan Court of Appeal would be upheld in its entirety, but it was a split decision of the Supreme Court of Canada where 3 or 4 of the judges went one direction.
5-4 split.
5-4 split. Yeah, so it's just always so confusing. What's the law in Canada? I mean, obviously the 5 is our law, but it's unfortunate. But good luck trying to explain it to your client. When you've got something that's like this that ends up at the Supreme Court of Canada, that's a 5-4 split. Like, what is Mr. Singer going to explain to him?
He gets to go back to the Court of Appeal for determination of the other ground of appeal that they never addressed.
Yeah. So, but it's unfortunate when we get a split like that, because it just really sends the message that even the judges can't agree.
Yeah. Yeah. I mean, it was interesting too who split. Like all of the, other than Cote, all of the women on the court split along the lines of
all the men plus Cote. So 4 men plus Cote.
Yep. No men on we don't want police on our property.
Yeah. Men seem to be fine with the police coming onto our property, and the majority of the women on the bench were not.
You know who answers the door when people are at home, right?
Yeah, it's usually
Usually warm.
Well, I wouldn't say that. No, I wouldn't say that. I think, in the evening time, the expectation is the man is the one who goes up and answers the door. Yeah, in my household, that's the case.
Anyway, so a couple things, big takeaways from this decision. First of all, for defense lawyers, I think what you're going to need to explore when you see a case of police entering onto somebody's property after a report of impaired driving or something like that, could be a report of any other criminal offense for that matter. Number one, pay attention to what they say in their police report is the reason for doing it. Because if they say, went there to investigate the report, that's not necessarily a sufficient purpose. And in cross-examination, you could easily get them to agree. They brought the ASD with them.
But they're always going to say now said, I went there to check on the health and well-being of the individual. So that's going to be the new lie that we will see police officers say.
Those defendants would just wanted to ask questions about the reports. That would also justify it. So the second issue that the court had to deal with was, where does this implied license stop? And in Mr. Singer's case, after they knocked on the window,
And
I did that because I'm concerned the
Oh,
Bluetooth was connected to the.
in Mr. Singer's case, after they did that, they knocked on the window for several minutes. Um, the police officer opened the door and then started dealing with Mr. Singer. There's an odor of liquor, et cetera, et cetera. And that's also open the door unless there is, another reason to do it under another police power.
Remember, this is all in the context of being in a driveway. We're not talking about on the roadway.
No.
We're talking about on the driveway. So Mr. Singer's asleep in his car and the police go and open the door. And so the court says, no, that's not right. You don't have the authorization to go opening the guy's door in the driveway.
Yeah. The
That's
only justification for opening the door would be an imminent public safety risk. So then the police have like an ancillary power to open the door to address that imminent public safety risk of maybe he's going to drive while he's intoxicated and so fast asleep that he's not responding to knocking on the window.
Or maybe there's some other medical condition that's happening to him. So that's, again, the way that it might be spun.
Yeah.
But the court said, find that evidence of that flowed from it as inadmissible.
Yeah.
So on the Section 24 analysis.
Well, they also found it to be like on the low end of the seriousness of a breach, because it was just the police didn't really understand the law at the time. And then they found it had a minimal impact on his rights because, he never left his driveway.
Problem is, it has a huge impact on his rights because the guy's A, at home, B, after that, he's subject to compelled to participate with an impaired driving investigation.
Well, he refused.
Well, I know, but I mean,
He didn't participate.
no, but there's the legal compulsion is right
Yes.
there.
Yes, facing the refusal charge. Yeah, it's, I agree. Interesting about the case was the Crown asking the court to also create a new ancillary power for the police, specifically that they have the power to enter onto private property or to open doors of vehicles in response to an impaired driving complaint. Like that there should be a specifically recognized police power for that particular act.
They could write it into the criminal code and wouldn't take much of a test because the court's already said that it's not hugely intrusive.
Yeah, I guess they could, but they're not going to.
You hope.
Well, no, I don't think they will because I think the way the Supreme Court of Canada sort of framed it a couple times in their decision and in also the McCollum case is that that's really a problem for provincial legislatures to sort out because it's road and highway safety. Because the criminal code can't just authorize walking onto private property without grounds. But the provincial legislature can.
Yeah, property and civil rights too.
Yep. So, yeah, overall, I wish that the majority had ruled.
You're sad about it.
I am sad about it. Wouldn't you be sad about it too?
I'm sad about it too, but I mean, this is how it was framed in the end, back to the breach, and obviously this is the glasses that they're looking at it through. Is that impaired driving is such a terrible, terrible, worst thing that you could possibly imagine. It's worse than fentanyl, and it's worse. It's a tip right on our society.
Epstein.
And therefore we have to take away all rights. Especially when it comes to impaired drivers. And then when it turns out that it takes away rights in some other circumstance, they're going to oh, we didn't know it would apply.
Well, the court also even referred to a vehicle driven by an impaired driver as a weapon. Like, I'm sorry, a weapon is only a weapon if you intend to use it in that way.
Yeah, the manner in which it's been characterized in the last few decades in this country is absurd. It gets to the point of being ridiculous, and it actually feels embarrassing to some extent.
Yes, I agree. So,
but you and I don't get to make the law.
No, we don't make the law. So yeah, there you go. The Singer case. Sadly, do you know what this means for me?
You probably got a dozen cases that are in the limbs or in the wings rather, where somebody was inside their home or inside their yard or inside their garage or inside their car.
Inside somewhere.
Yeah. And now we've got a
try and figure out what it means for their particular case. Did the police officer open the door? If they opened the door, what was their intention? What was their intention when they went on there? Do they know? Do they remember what their intention was?
Yeah, well, it is really about their intention because they rely on the seminal case of Evans where, the officer sniffed his way down a hallway and then knocked on the door. And the purpose of his entry was to smell for marijuana. So you should look for evidence in the police reports that the police were there not for communicative purposes, but for evidence gathering purposes, that they had an ASD in hand. They made a demand very quickly. They, uh, you know, they intended to look for damage on the vehicle. Like sometimes they could.
If you leave your ASD in the cruiser and it takes a few minutes, then it's going to be a delay, and damned if you do. If you bring your ASD with you and your intention is to investigate an impaired driving case, then damned if you do.
Well, for our listeners, I think that they need to know one thing they can do to protect themselves. There is something you could do to protect yourself from the police using this power that the Supreme Court of Canada said will work.
Yeah, you could express to the police in some form or another that they are not entitled to be there.
Yeah, I mean, you don't even need to express it to the police. A no trespassing or keep out sign would be an indication that there is no implied license at that property. But I'm going to make a bunch of stickers and I'm going to put them on my front door and say, no implied license here. Implied license revoked.
Yeah, you could put that on the front door of your house. You could get a little sticker for your car somewhere. Doesn't have to be huge. A little sticker for your car somewhere. The only problem is you'll get pulled over one day and you'll have some police officer who thinks you're a sob sit.
Or they think that you're when it says license revoked, they think you're a prohibited driver. Yeah. But yeah, I mean, you should do something.
Do not touch my car.
Even if you don't think you're ever, going to drive drunk or you're ever going to commit a crime that the police are going to show up and investigate, it doesn't take a lot to get reported and investigated. And you innocently stumble in the parking lot on your way out of a pub or on your way out of the liquor store. The number of files I've had where someone stumbles in the parking lot and then gets called in.
I walk out of a distillery at 10 o'clock at night after sitting there doing paperwork or loading boxes for 3 hours. And I've got fallen arches, flat feet. I wear orthotics and my heels and ankles hurt. And I stumble and I think, oh God, guy in his 50s walking out of a distillery, stumbling.
Yeah.
You're just going to assume that I'm drunk.
Yeah. So,
Lots of people get detained and they, when breath samples are not obtained.
Also, you go.
Lots of people who have medical.
What are you going to do? You're going to go home. You're going to maybe you get home from a long day of work, which is why you were stumbling because you're over 50 and you do physical labor, and then you crack a beer, and then the police are at your doorstep. And maybe you'd have a defense if you were charged criminally, but in BC, half those people are going to get IRPs.
Honestly, half the time I pull into the driveway at home, I turn off my car and then I look at my phone and I might get sucked into TikTok or something like that. And I could fall asleep right there. Next thing you know, they're going to be making an ASD demand, have a defective ASD, and I'll end up charged with refusal.
Yep. All right, let's move on to our
ridiculous driver of the week.
Yeah, it's a good one. Somebody sent this one too.
Yes, this was user-submitted ridiculous driver of the week this week. It was an individual
in Calgary.
I was going to say
Edmonton. It was on CTV News.
And they had basically turned the interior of their vehicle into like a living room.
Well, they put drapes on the windows on the side, like actual drapes on the side.
You slip it in your car.
You might, I don't know what the rules are for tinted windows in Alberta, but in British Columbia, you can have no tint on the front side windows, passenger, driver's, windshield, only at the top, like 5% or whatever it is of the window. So you can't impede it. And there's good reasons for that. And there's no excuse. Like it's just got to be done. Well, this person decided, well, I guess if I can't put up window tint, option B, drapes. So you just imagine a little string, a little rope.
I mean, technically drapes are not against the law in BC. It would just be you would have to open them while you're driving so they don't obstruct your view. Because driverless view obstructed is an offense. But if you had drapes that you closed other times, or on the windows that don't obstruct your view?
Well, I mean, I put up covers on the windows of our company van just because I don't want the interior to get baked.
No, I don't want
Um,
police looking in my car when I'm sleeping in my car
Exactly.
after driving home drunk.
Yeah.
So I'm going to put on my drapes
Don't
and
drive.
close them.
You don't drive home drunk,
don't.
but you.
I also don't have a driveway, so
That's true.
unfortunately, I am not captured by the
Yeah,
profession of singer.
you could. You have a pool table in your driveway.
It's true.
Yeah. So no drapes, no drapes. Not while you're driving in any event.
No drapes while driving, no drinks while driving, and no cops allowed somewhere
Yeah.
on your property line.
Yeah. Stay in school and don't do drugs.
Yeah. All right, that's our podcast. If you have a driving law related issue, you can find us online at vancouvercriminallaw.com or give us a call at 604-685-8889 and tune in next week for another exciting episode of Driving Law.